Welcome, everyone, to Diversified, where our mission is to have you live in a life filled with wealth, health, and happiness. Today, we have a very special guest and a dear friend of mine, Michael Salad, Esquire. Michael Salad is a partner in the law firm Cooper Levenson. He works in the business tax and estate planning practice group. He concentrates his practice on business transactions, tax matters, elder law, probate administration, asset protection, real estate, special needs planning, and estate planning. Welcome, Mr. Salad. How you doing?
I'm great. Thank you very much, Andrew. Appreciate the opportunity.
Absolutely. So you've been a friend for years. You've helped many of our clients. Let's start by talking about elder law. So we have a lot of clients that are now getting to that stage, or have folks who are getting to that stage, looking to protect their assets for long-term care purposes for the kids. What should people be thinking about when it comes to elder law planning and protection?
It's definitely a different area from estate planning. An estate plan will get you with the basic wills, revocable trust, living will, power of attorney. They'll get you to that point. But once you are at the point, usually in their 50s, 60s or older, and that is starting to come on the radar, we have a different set of documents that need to be considered. And they don't make sense generally for clients that are younger. But as we get to 60s and older, and many of our clients who have children may be willing to place assets into an irrevocable trust for Medicaid planning purposes.
Okay, so a lot of it's for Medicaid type planning, using special trusts and things of that nature, because now they're sort of on the backside and looking to protect those assets. So essentially, the government won't take them, and they can still get different benefits from the government.
Yes, exactly. That's the idea. And the children or next of kin are usually much older at that point, and they're in their 60s and 70s, and they're comfortable with the concept of potentially taking assets out of their estate and getting them to the next generation, such as real estate and other investments, so that those are not countable assets within that 5-year look back period. It's better to start that process. It doesn't work for every client. Some you lose a step up in basis with certain assets. It's not a one size fits all, but it's something to start considering at that age.
So it sounds like the best time to really start thinking about this is not the day before you may need care. It's a couple of years. So mid 60s to 70s, start looking at this stuff, because some of this has a 5-year look back. So you want to make sure you get ahead of that early and often.
For sure. Around the time that somebody would probably consider long-term care insurance is probably an appropriate age, similarly, to consider more of a established elder care plan.
Gotcha. Okay, so that's now we're talking as far as elder care planning. Let's talk about estate planning, which generally is wills, trusts, power of attorneys, healthcare proxies, all of that. At different ages, people should be looking at different things, right? So let's say pre-family, family, and with minor children, and then family with adult children or children that just don't need any sort of care, or you don't have children. What's the different things you should look at within estate planning? Because all too often I come across people who don't have these documents because they don't think they need them yet, or potentially lazy, or not on their mind, or don't think the ramifications are dire enough. Can you speak to sort of those three demographics and what the key reasons they would engage and get an estate plan done for them?
Sure. The first stage before a person is married, or perhaps married and does not have children, we need basic documents generally. Will, living will, power of attorney. The biggest concern is if you pass away suddenly, do you want your assets to pass to your parents, to your siblings, nieces, nephews, charities? Or if you're married, probably to ensure that your spouse will receive everything. Make it clean and easy so that there aren't any disputes among the family members. And if you become incapacitated during that period of time, you ensure that you have someone able to make financial decisions, to pay your utilities, your mortgage, your bills as they come in, and end-of-life medical decisions. Once you have children, the biggest issue is usually who is going to become the guardian of the child or children. This is probably the most difficult decision that my young clients make when they are going through this process. It's usually the most contentious.
I've been there.
I explained, what's that?
I've been there.
Yeah, we all have. I just recently made my wife sit down and go through this process as well. And so I get it. It's not a fun thing, but there are practical issues that we can bring forth. For instance, okay, one side of the family lives in California and one side of the family lives in Pennsylvania, and the children live in Pennsylvania. If it's a toss-up, you probably want the people in Pennsylvania there because they're going to be able to just jump right in and not have to uproot the kids across the country where they've just lost their parents and now they can no longer even be around their friends and their all the activities they do. So there's a practical aspect of it as well. After that stage, so now the children are older, they're beyond 18 years of age, we're not worried about guardianship. A very common question is, okay, my child's 20 years of old, they're off to college, they're in the workforce, whatever it is. What happens if something happens to them and they become ill? Well, now we want to start talking about basic documents for them. The 18 to 20-something-year-old, making sure that they at minimum have a basic will, living will, power of attorney in place as well. The last step being, okay, now my children are older. The biggest concern is what happens if my child gets divorced? And our clients are quick to bring that issue up, but then they always think, well, it's probably not going to happen to my kids. I'm sure they're going to be in great marriages. Well, if you have two kids, just pure statistically, one of the children's marriages will end in divorce, and nobody thinks it's going to be their child. There are very simple ways that we can update trusts or implement trusts to provide assets to the children, but better keep those assets separate so that they are not commingled and subject to what's generally called in many states equitable distribution, meaning those assets become part of a marital estate and are separated and divided between the spouses upon a divorce.
Right. So, you said something interesting there, which people question, which is trust planning, trust in general. Do you have to be a multi-millionaire to do trust? I know you and I are both big proponents. You started to go down that path, but talk about sort of trust planning, because everyone thinks that you have to be Scrooge McDuck to start talking about trust, but I don't think that's the case. What's your take?
I agree that it is one of the biggest misconceptions of estate planning that there's a need to have substantial wealth in order to implement trusts. Sometimes trusts are as simple as a will, if not simpler. Trust can be revocable or irrevocable at its most basic core. And a revocable trust, meaning you can change the terms, modify the terms, update it whenever you want, does not provide asset protection generally, but it does provide a level of organization and probate avoidance that is often very sought after by our clients. It streamlines the process, makes it much simpler. It provides a level of privacy. And in some states, it has much more benefit. In Delaware, for instance, there is the county probate closing fee assessed in each of the three counties. It's a different rate, but all of that is generally avoided by using a revocable trust. In other states, like Florida, the probate process is horrific, and you can spend easily tens of thousands of dollars and spend a year or two or three going through probate. All of that can be avoided with a basic revocable trust. Clients that may only have tens of thousands, hundreds of thousands of dollars and don't necessarily have millions of dollars can greatly benefit from a revocable trust. That's really no more expensive than a will. It's very easy to implement and should be implemented, particularly for those in states where there's probate closing fees, difficult probate, or they own property in multiple states that will necessitate probate in multiple states.
Right. Which speaks to a great comment or notion, which is, what's the difference of using an attorney to do this? Or I've seen people come in with legal Zoom documents that they spend $100 on, and we always send them to you to get reviewed and beaten up on. But what's the benefit versus cost analysis? I mean, you're kind of speaking to that to some degree. There's a lot of these mistakes are made, but talk to what you see the main differences.
Sure. Most common example that I see is wrong governing laws. It's just a basic type of thing where somebody who comes to me, they're a New Jersey resident, and they show me their existing documents, and I say, why does Texas law govern this? Why are there references to Texas or Delaware or California? I said, did you live there at this time? They said, no. I said, well, I'm not sure that they're going to really hold up. Why did you select this? They said, I don't know. It's just the default that was selected. So I see things like that all the time. They are not tailored generally all that well to the clients. They are probably more times than not incorrectly executed, meaning they didn't sign in the right place, or they're not self-proving, which is meaning that in a court after a person dies, you have to go through a more extensive process. It didn't have a proper notary, or it didn't have two witnesses if the state requires that. I find a lot of nuances like that are not covered. And now you have documents that are wholly ineffective. They're not worth anything. They will not be honored under the law of the state that they were executed in. Often they're the wrong types of documents. Somebody really needed a revocable trust, and they selected an irrevocable trust and didn't realize that they've lost all the control over their assets and they can no longer modify the documents. So I have found on numerous occasions, more times than not, there are glaring issues. And for the few $100s that you save for a basic estate plan by doing something online, it more times than not is not going to work out effectively and meet your needs with basic trust provisions for the kids or guardianship or other things that we bring to the table, talking about insurance and how to protect assets, asset protection planning, and those types of basics you're not going to get from LegalZoom.
Yeah,
maybe one day,
right?
But
hopefully
the technology's not there yet. I hear Michael Jordan is investing heavily in new technology for estate planning that's going to tailor all of that in the coming decades. So maybe I'll be out of a job, but for right now, I don't think the technology is quite there.
Fair enough. Well, if you lose to Michael Jordan, you wouldn't be the first. So, okay. Leave us with one final tip when it comes to estate planning in general that you want to let everyone know or remember. And then I want you to tell everyone how they can get in touch with you.
Sure. I would recommend reviewing the documents every few years. It's an important process to go through. It's an organic process, estate planning. It's not one size fits all. Biggest things to look out for are special needs. I have a lot of people who sign documents either before they've had children or right around the time they've had children. And now with, I think, 1 in 60 something children having some form of special needs, it jumps out and is really important to have special needs trust provisions. So that is definitely something to consider. If there's a death in the family, that's usually another opportunity that we need to take a look at things. And other substantial life changes. You get married, you get divorced, a child gets married, a child gets divorced. Those types of life events usually will trigger some change being necessary in estate planning documents.
Perfect. Love the advice. Great guidance, Michael. You're always thoughtful and generous with your time. And for everyone listening, he's one of the top attorneys around. I highly recommend him. How can people get in touch with you?
Thank you. I appreciate the kind words. I'm easy to find. I'm all over. You can find me on our website at cooperlevenson.com. And my direct dial is 609-572-7616. It's msalad@cooperlevenson.com. And type me in and you'll have no problem finding me, and always more than happy to help out your clients and point them in the right direction.
Absolutely. And we'll share all that info below. And of course, feel free to go through us, any of the planners here. We can obviously put you in touch. Michael, thank you so much, as always, for your time. Learned a lot, as always. I'm sure everyone watching this is appreciating it. And with that, I will say thank you and wishing everyone, as always, to stay wealthy, healthy, and happy. Take care.